Hi, everybody. It's Kate. I am back and it's 2 o'clock. I just wanted to run through the committee members to see that everybody is back. So,
This is the moderator. Let me
Sure.
go ahead and resume the recording.
Oh, yeah. Thank you. Sorry about that.
Yeah, just because it's gonna give an announcement again and interrupt people. So,
Gotcha.
This
Go ahead.
meeting is being recorded.
all right.
Thank you.
It does appear that we don't have an audio connection for Debbie, so we may want to also wait for her to reconnect.
Okay, will do. While we are waiting for Debbie, if each of the committee members can maybe just use the little raise your hand thing or something just so that I know that you're back, that would be helpful. That way when Deb gets back on, we'll be ready to go.
Hi there, this is Zima. I don't see a raise your hand, but I am here, but I do have to run in a minute.
Oh, okay.
I would say, I'm not sure if we can record the hand vote. I would suggest getting it an audio vote at least to establish a quorum.
Oh, Lynn, I was going to do that once Deb was back. I just wanted to see who was here, so
Oh.
when she came back, we knew we could start doing that.
My
But
apologies.
understood. And so Zima just indicated that she also has to leave in a few minutes. And so, Lynn, good thing you're back, because if Zima leaves, David is gone, and Lee has to leave in about 15 minutes. Does that mean we then lose our quorum? And if we do, what then?
You would lose your quorum. You can still present items for discussion, for presentation, for information and discussion, but you wouldn't be able to vote or take action on any of them.
So
I'm
if
not
it's
seeing any
okay,
action
I
items.
will drop off of the computer connection and I can connect on my phone if someone will let me back in so I don't mess up the quorum.
I was going to say I can do the same. I just won't be in front of the screen, but I can still be on the call.
Yeah.
Does that work, Lynn?
Yes, it does.
Okay, great. Well, thanks to Lee and Zima then for agreeing to stick around via phone. Appreciate it.
Sure, absolutely. So I'm going to drop off and I'll reconnect in just a minute.
Okay, thank you.
All right, this is the moderator. Looks like Debbie's back, so we should be able to continue.
Thanks, Sarah. I don't know if you heard Zima say she's dropping off and going to dial back in from her phone.
Oh, I apologize. I must have missed that.
Just so you can keep an eye out for her.
Great, thank you.
Okay, so now that we have Deb back, I'm just going to run through to make sure that every one on the committee is, other than David, who we know is not coming back, is back. Lee, you are the first person on my screen. I see you. Can you just say hello?
Hello, I'm here.
Thank you. Joseph, waving his hand, present and accounted for. Margaret?
Yes, I'm here.
Thank you. Melanie?
I'm here.
Thank you. Let's see. Scrolling through here. Did we lose Katzen? Seeing him on the list here. Oh, he disappeared. Katzen, can you just let us know you're there?
Yeah, no, I cannot unmute myself. Now I can. Can you hear me?
Now I see. We hear you. Thank you.
All right.
Okay, I think that's everybody. So thank you, everyone. We have enough people to have established. Oh, Zima. Did Zima dial back in? We're okay without her for now because Lee is still here. Oh, I see her. in the attendees?
Oh, there she is. Thank you.
Thank you. All right, awesome. Zima, can you hear us?
I'm here. I can hear you.
Okay, great. Thank you. All right, awesome. So we have a quorum. We can move forward. The next item on the agenda is item 6, which is the status update regarding a number of different regulatory packages. So I will open the floor to the Bureau to cover this.
Good afternoon. It's Yvette Johnson again. Along with David Dumble and Chief Cochran, I'll be covering the regulatory updates. We are pleased to share this information with you regarding the proposed changes to the Bureau's regulations. As the committee is aware, there are a number of procedural steps that the regulations need to go through prior to adoption, and we are bringing these proposed changes to you for early feedback prior to moving forward. So the first item that we have is as an update on the verification of exempt status application. I'm pleased to say that the regulatory package was submitted to DCA for approval on July 28th, and we're waiting to hear back. So I don't have any further updates on that at this time. Okay. The next item that we have is the student wage, the discussion on the draft language for labor market outcomes, also known as the student wage data. So in the meeting materials, you have the proposed draft language for the labor market outcome data reporting. And that's on page 60 of your package. So the Bureau is proposing the following changes. And it's going to be an addition of the California Code of Regulations 74110D. And so with that, with 74110D, it incorporates newly required reporting into the Bureau's existing annual report process, given that it's an existing data collection effort and already happens annually. The proposed language includes instructions on how and when the data should be submitted via the online portal.
This meeting is being recorded.
And I don't know if you guys want to take
This is Moderator. It appears someone's mic is unmuted. I'm trying to find who it is. So I'm just going to go ahead and mute everyone. Okay, click the mute all button. So if you need to unmute, if you could please unmute your microphone.
Okay. So I don't know if you would like to cover these section by section or just go through the whole package, proposed package, and discuss at the end, which would be preferable.
If that's preferable for you, Yvette, that's fine. You can just cover the full package, and then we'll do a discussion of all three, and then we can open it to comment after that.
Okay, great. Okay, and the next section is 74110E, and that clarifies that the failure to submit a completed annual report is considered a material violation. And so it's really underscoring the importance of the submission of the report. And it also provides the Bureau with the opportunity to take action if a school does not submit a completed report. And we're also proposing to add section 74112. And this section outlines which data elements are to be reported to the Bureau. If you would like to read through the language, and then we can go ahead and I'll open the floor for discussion on anything. From the committee.
I have a question in regards, this is Joseph. The addition of and clarification, as you pointed out, of the failure to submit a complete report with the fact sheets and catalog, enrollment agreement, and so forth, as a material violation. How does that compare to the current standard or threshold for failure to submit?
Trying to unmute myself. So it really, in 949 to 9.8, where it talks about the uniform data reporting regulations, it already provides that the failure to submit the annual report is a material violation. So we just wanted to express, really put that out there so that people understand the importance of it.
So this is a clearer communication rather than an actual change in the standard.
Right, and that way they don't, folks don't have to go back and refer to the statute to get that understanding. It's spelled out right here in the regulation.
Perfect. Thank you for the clarification, and I commend you for doing that. That's always helpful to not have to look back at the reference for schools.
Thank you.
Yvette, I have a question about, hold on, I just keep switching back and forth so I can unmute myself and then look at my documents. So under 741120, where you're adding the new information that's required under that 1346, with the social security numbers and the taxpayer identification numbers, right now, is this language here for under O intended to be that they're collecting this data, but schools won't be providing it to the Bureau until you have the IT certification that your system is sort of capable of handling this? So is this right now just a collection, but eventually will be reported?
I'm going to have to ask David on this one.
Yeah, I'm trying to log in. The section of, let me get the number right, 94, excuse me, that's a different one. The section of 1344 that required the collection of the data became effective on January 1st of that year. The section that authorizes us to collect the data and have them require them to report it does not become effective until the Bureau's computer system is certified to be able to handle the data by the director of DCA. So therefore, that creates a bit of a difficulty in dealing with this issue. But right now, schools are already required to collect this data. We are not authorized to require them to report it until the computer system is certified to be capable of handling and processing the information.
Thanks, David. That's what I thought. And I just wanted to make sure as I was looking at this from a regulatory perspective that schools understand that under O, when you're saying the institution shall provide this data, they're not saying that this will be due in this current annual reporting cycle or and I understand this isn't finalized. I just want to make sure schools understand that this is not finalized and this is not something that you're reporting yet. But as you said, they already should be collecting it because that part already started. But just for any school that might be listening, just so they understand there's still a time lag here.
Yes.
Okay, thank you. Yvette, you want to keep, unless anybody else has any questions on B, I think we can move to C.
Darn unmute button. Okay, so the next section C is discussion on draft out-of-state institution registration forms. With this one, I'm sorry, I'm trying to get to my notes.
While you're doing that, I'm sorry. I was just going to say, as to the labor market outcome data reporting, I feel like I'm just trying to absorb and coordinate all the information. So I'm assuming it's okay if I have comments to submit them to the Bureau after the meeting in writing.
Yes, that's fine. Okay, so for the next one, proposed regulations have been drafted to implement AB 1344. In a previous advisory committee meeting, members were asked to provide input regarding the application for registration or re-registration. Thank you to the several committee members that provided feedback during and after the meeting. Comments and suggestions were received, and several of which are included in the proposed changes. So beginning on page 61. I'm sorry, that'll be page 63. On page 63, you'll see the proposed changes to the application for out-of-state registration. The application itself actually begins on page 66, which you can use as comparison for the changes that we are proposing.
I think for me, it's easier if we just go through the application. I just wondering how other folks feel.
We can do that, and I can just discuss the changes that were made. The proposed changes.
Yeah, that works for me too, because the summary is good, but it's easier to see them in the application. So I'm fine with doing that as well.
Okay, so on page 1, we amended the last sentence in the first paragraph to change the registration fee being valid for 2 years to 5 years. And then we also added the word registration and re-registration. We added the word application to ensure that they know that we're talking about the application. In the next section, we deleted the section that talks about the listing of the 4 items that need to be included in the application. And we added the section that says all items directed to be submitted in this application must be included for the application to be considered complete. And we also added the section that says the Bureau reserves the right to ask for any supplemental information it deems relevant.
This is a minor detail, but the top of the page should out-of-state institutions be hyphenated? I'm sorry, it's a really minor detail I just noticed.
Okay, thank you for that.
And I'm wondering if it wouldn't be clear if the added paragraph or paragraph, all items directed to be submitted, came before the first paragraph and was the beginning of the second paragraph. So it would read all items to be directed to be submitted, da, 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 and the Bureau reserves the right, da, 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 and then to register, the following must be included. And to make it even clearer, maybe in all items directed, it could say below or something along those lines.
Yeah, I believe that sentence before the deleted list of documents should also be deleted as well. So the second paragraph should start with the statement that all items must be included.
I actually think you need that first sentence or some variation of it, because otherwise you don't have a directive saying the following must be included.
So, but we're taking out those four listed items. So it can, so thinking maybe just to register or re-register or re-registration after expiration, all items directed to be submitted in this application must be included. Just leave it with the beginning of the sentence. and take out the
That sounds right to me, Yvette. Sort of
I-
a combination of that sentence with the new underlined language kind of merged together.
right.
I think neither of those sentences specifically says you must include the following information, and you need that for a directive somewhere in there. Maybe if you change it to say to register, re-register, da 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 da, all items listed below must be included with the information to be complete the application. You've got to get there somehow. The directive saying you have to provide the following, and you can do that in different ways. I don't need to wordsmith it right now, but that directive needs to be in there.
Margaret, so I understand the concern. There's the line in the proposed version that says all items directed to be submitted in this application must be included for the application to be considered complete. Is your point that the directive is strongest if we actually list out the items in that section rather than saying everything, kind of a blanket reference to everything that comes below?
No, what I'm saying is all items directed to be submitted doesn't say you are directed to submit the following items. So you have to someplace say you must submit the following with your application.
Got
or
it. Okay.
Something along those lines.
That's
So
helpful.
you need something that is directive, not just descriptive.
Got it.
Okay.
Should we move to page 2 or wherever the next edits are?
Okay. And the next item is page 65. Page, if we go to page 67, which begins the information being requested for the application. That's pretty much laid out the same way. You'll find the next change on page 68, which talks about the state authorization. And so this section previously asked for that the school provide information of the institution's approval and to operate in the state of its main administrative location. We've also added a section in there that states that the institution should submit their financial responsibility composite score for the past 5 years as determined by the U.S. Department of Education, as well as any information regarding the institution's placement on heightened cash monitoring, if applicable.
What if the institution is not Title IV participant?
And that's why it says if applicable. Oh, so you're asking for those schools that are not, what do we do with them?
Right. I was reading the if applicable to be relating to the HCM, not the composite score. So I guess it's sort of both, because you wouldn't be on height cash monitoring if you're
not. Right.
I'm sorry, can I go back just a second to the bottom of the previous page? I know you didn't make a change in this, but is there some place where affiliated institution is defined that's in section 4 of the application? Because I'm not sure I understand what that means.
So if you look at the last sentence in section 4, it says an affiliate is an entity that is related to the out-of-state institution by financial interest or other means of control.
Well, by that definition, I could have my in school that is under the same corporate authority that has a school in California, but also has a bunch of state. And it would, one could argue that affiliate, because they are connected by financial interest or other means of control. So, a corporation fits that as well as schools that are not the same corporation. That's why it's a little confusing to me how you distinguish between the two.
Okay, so you're suggesting that we add a more direct definition?
Yes, yeah, it's hard for me to understand what's an affiliate that's not actually a part of the school. So, because if you have a school owned by one, let's say one person, and it has a bunch of, or it has online education, but it has one site in California, we treat it as an in-house school. But if one person owns two corporations, are you saying here that that means that, and one is in California and the other is just out of state distance education, you're saying that that's an affiliate that's in state? I'm just confused by, how you distinguish whether a school is out of state if it does actually have affiliates in California. And maybe it's not, maybe it's something that's really a legal answer as to what that means in terms of, I don't know, school ID numbers or something. I don't know. It's just not very clear to me. So I don't know that you need to figure it out or right now, but that's something if you could have, maybe take a look at and have your legal take a look at and just see if it's, if it's a definition that rules certain things in and other things out. Because to me, it's not clear that it does right now.
Okay.
That makes sense.
I'm sorry, I was jumping back, and I know you were on the next page. Sorry about that.
That's okay. Okay, so we were talking about, previously we were talking about section 6 on the state authorization. Any comments, suggestions?
I think my suggestion with that one would be to start that added sentence with "if applicable," attach the institution's composite score, as well as information relating to heightened cash monitoring. Because you're only going to add it. Your heightened cash monitoring would only be, like you said, it's not everybody isn't on HCM, but if you sort of start with the "if applicable," that would then indicate to schools that aren't Title IV that you don't have to worry about this. And if you are, then include your composite score. And if you could always just put NA for heightened cash monitoring, just so that it's clear that. And the reason that I'm bringing this up is because Sarah, which of course California is not a part of, has separate financial responsibility scores that that have sort of gone out into the states that are tied to Title IV for Title IV institutions, and then not if they're not, and so it gets a little confusing about what that looks like. The other, so I just don't want people to be confused about what this means. Like, are you talking about meeting California's BPPE financial requirements? This is the U.S. Department of Education's financial responsibility composite score that you're asking schools to disclose, right? So just making sure it's clear that that's what it is. And this is, I'm not sure where this came from as far as why we're adding it. But if the idea is you just want to make sure that schools are, in compliance with the Department of Ed in whatever way that looks like, I think maybe starting that with "if applicable" might just make more sense.
Okay.
I actually think that section needs to be broken into two. It's asking for two things. One is verification that it's approved to operate in the state, period. And that would apply to everybody. And then the cash monitoring section should be in a separate section because it only, as you say, only applies to schools that are approved by the Department of Education. So you would be initialing once for, it doesn't make sense because you'd be initialing when it might not apply to you. So I would break those two out into two separate sections. And the title of that section is state authorization. So it should just refer to state authorization. You should have a separate section that is titled something like, financial responsibility or something that would then be dealt with separately. And the other thing I would say on that is it says, in that last sentence, as well as any information regarding the institution's placement on heightened cache monitoring. Any is a very broad term, and I think it would be better if it had more specificity. If what you want is, for example, the terms of the cache monitoring notification, the date of the notification, or the date it was announced, the date it became effective, the current status, whatever the specificity is that you want about that, rather than just saying any information, because it leaves it a little, I think, vague for schools to know, what exactly you want there.
I agree with Margaret on the second part there. Well, actually, I agree with Margaret on both things. I do think that having that financial responsibility in the state authorization box doesn't really make sense because they're not related. So having a separate section that is specific to Department of Education financial responsibility as its own box makes sense. And then as far as heightened cache monitoring, maybe you could break it down and say attached is the institution's composite scores for the last 5 years. That's easy enough to do. And then if the institution is currently on heightened cache monitoring, please identify 1 HCM1, 2 HCM2, like maybe 2 tick boxes, and then a date department took action to place them on this, on whatever it is. And then because you reserve the right to ask for additional information, if you want to know more about that, you can always ask. But HCM1 is a defined thing and HCM2 is a defined thing. So you'll know they're either on reimbursement or, whatever the requirements are for HCM1, and HCM2 are generally consistent, right? So as long as you know which one they're on and when they went on, that should probably be enough to just give you the general sense. And then if you want to know more, you can just ask them to provide additional information.
Kate, are those forms pretty much boilerplate, or is there individual language for a school depending on the level or type of cache monitoring or heightened?
It's generally pretty consistent. If you're on HCM1, it's one process. If you're on HCM2, it's a one process. So the process itself is pretty consistent. The only thing that might vary wouldn't be necessarily related to the heightened cache monitoring. It would be if they had other financial responsibility. So like if they had a composite score that was in the zone, well, now they're in the zone and maybe they have other limitations, but that doesn't mean they're on HCM1 or HCM2, right? So I think if you identify which one of the 2 HCMs they're on, that will give the Bureau enough to know which process they're under, because the process is going to be basically the same.
I don't know.
And by that, I mean anyone on HCM1 is under one process, and HCM2 would be under that process.
I don't know enough to know otherwise, so I leave that to folks who do know in the Bureau. I guess I was just trying to figure out if it made sense for them to attach any particular document, and from what you're saying, you don't think so, but I have no idea, so I leave that.
Yeah, I mean, I suppose if the Bureau wanted to know, because basically when an institution gets put on one of these, they just get a notice from the Bureau that says, based on whatever the reason is, your institution is being placed on HCM1. Here's what that means, and it's boilerplate basically. And so it would be the same for HCM2. But you could, institutions would have documentation from the Bureau indicating. I'm sorry, not the Bureau, the department. Yeah. So I mean, you could ask for that, but I don't know that it gives you much more than just having them identify whether they're on HCM1 or HCM2 and when they went on it, because unless the Bureau is unclear on what the 2 mean and what it means to the school, then it would be basically the same regardless of which school it is, because if they're in that category of heightened cache monitoring, the rules are basically the same thing.
Okay, so thank you for your comments and suggestions for that section. Okay, the next item we have is section 7, which we've totally revamped. It's as opposed to just submitting the catalog and enrollment agreement, we wanted to make sure it was tied into the student tuition recovery fund. So we renamed it that, and we're asking that the institution provide copies of their current catalog for their California students, And we want to ensure that it has the required student tuition recovery fund disclosures. And the law also states that if the school has an enrollment agreement, that they need to submit a copy of their enrollment agreement as well. And so we wanted to specify that for institutions that use enrollment agreements, we want them to provide a copy of that as well. And we do have the information there as well that says for institutions that do not use enrollment agreements, we still want to know how they are providing the student tuition recovery fund disclosure to their California students.
I think that the second aspect of that, for institutions that use enrollment agreements, again, it doesn't have direct, you want the enrollment agreement as well as, the showing how the STRIF notifications are made. So I think it needs to say, for instance, institutions that use enrollment agreements attach the enrollment agreement showing how the required STRIF notifications are made to California students.
Okay.
And then for institutions that do not use enrollment agreements, the third one I think is fine.
Yeah.
What I am wondering, though, now that I'm seeing that is, wouldn't most schools have to have some kind of a contract with their students? And if so, maybe the second one should say, attach the enrollment agreement or other contract document you use with California students.
Enrollment agreements are driven by state law, and not all states require them.
Right.
And not all schools have contracts at all. A lot, so that I think that what they have probably is more inclusive, because it might be a contract or it may not be. It might just be like a disclosure. So
okay, that's fine then. I think it just needs to be more of a directive. If for institutions that use enrollment agreements, attach your enrollment agreement. And then if it's supposed, and then showing how, and documents showing how the required STRIF notifications are made to California students.
Okay.
in the last part of that section, the attached are copies of the records required to be kept for students for the past 5 years. Are those records, do they contain like personally identifiable information like social security numbers or anything like that you would need to be kind of having special directions on how they would provide them or submit them? I'm just not sure what that section for the records is. I don't remember off the top of my head what records they're maintaining.
Trying to pull up the reg associated with that real quick. Listing. Of course, when you're looking at things, your computer doesn't. That section, it's requiring the student's identification number, their name, email address, local email address, their address at time of enrollment, and the enrollment agreement, courses and course costs, the STRIF assessment, institutional charges. So pretty much what's included on the enrollment agreement already.
Yeah, I pulled up the section 2, and you're right. It doesn't look like it's anything that would be particularly concerning. I just wanted to
Right.
make sure it wasn't something, because the Department of Ed has like a whole elaborate process for submitting student PII information to
Right.
them. And so I just wanted to make sure that, because normally these are records that the institution just maintains. They're not submitting them to the Bureau unless requested. And it could be quite voluminous if they have a lot of California students and it's a five whole years worth of data. So just wanted to make sure there's a way of, making sure that that's a doable submission that isn't going to require a bunch of second steps.
Any other comments on that section? Okay, the next thing we have is section 8. And it's on page 69. And it's the request for an explanation of any prior or pending actions. And in that one, really the only thing we added was the re-registration and the name of the application to make sure that we're consistent with that. The same thing goes for number 2 and number 3. The main thing that's been added is in section 5. On number 5 in section 8, which is we're asking for the document if the institution is currently contracts with any third parties for advertising and recruiting. And we're asking if you're asking for the institution to submit evidence of that.
It sounds like, or it reads as only if that agency or group within the past 5 years have settled or been, you using the word adjusted, but maybe you mean adjudicated or judged, or to have liability for a civil complaint for more than $250,000.
Yeah.
Adjusted should be judged or adjudicated.
Right.
Also, this one doesn't make sense to me because, first of all, if you're contracting with our advertising or, basically like a recruiting or, that kind of thing, or even instruction, or even student services, any of these things, you have somebody that you're contracting with. If they have had some issue unrelated to you, and this is so broad, a civil complaint for more than $250,000. So that could be a wage and hour lawsuit from an employee. Like, this doesn't really seem to have any connection to what would be a consumer protection issue. So this, to me, if the concern is, the question is, we want to make sure that an institution isn't basically contracting with a bad organization, then I don't think that this is really this doesn't seem like it's getting to what you're trying to get to, because it really should be aligned with a civil complaint. I guess is too broad. That could be anything. That is basically anything that's not a criminal complaint is a civil complaint. So it could be anything from a discrimination, maybe you have an employee discrimination case or a wage and hour case or someone slipped and fell or whatever. That doesn't seem like it's relevant here. So I would suggest narrowing this to something that is not just a civil complaint, but a civil complaint that is in relation to the provision of, these services, that the institution participates in or something like that, because this just seems way too broad to me.
It appears, Kate, to be like the intention is an OPM net, basically. Catch an OPM at the broadest level. And anything that an OPM or any of these partners did on behalf of a school, the school technically would be liable for those things. Like I can't think of a circumstance in which your vendor would have been held responsible for doing something for your students that you yourselves as an institution are not responsible for.
I agree with you, Joseph, but that is not how this reads. It's not limiting this to that. So yeah, I agree with you. I think that's what we're looking for here, is if they've been adjudicated or settled a case for this dollar amount that was directly related to, provision of services to students or to institutions as it relates to the students, because this it just seems like this is basically saying anything that they've ever done wrong that resulted in a $250,000 settlement.
I agree in part with what you're saying. I think there's two aspects here. I think that knowing that a school is using third parties for these services in and of itself is helpful to know. And so I think one thing would be, if you have used, identify these companies, and then it's easier to determine, is this somebody that's really out there using a lot of third party lead generators on the internet, et cetera. So that's one thing. So then you can keep an eye on it. The second thing is, I agree that it should be related to, and I think there's language in some of the other provisions that relates to consumer fraud, unfair practices, something like that. And then, so the second part would be identify any that have whatever this language is, in which the complaint was for $250,000 or more in relation to consumer da-da-da-da. There's languages elsewhere in this application, so I think it can be adapted for this. And the only exception to that, I think, is I'm wondering, maybe this is something to be put some more thought into, whether when you're talking about lead generation, you're interested not just in consumer fraud or unfair practices, but as to their practices with their employees or so-called independent contractors. But I think maybe that's overkill. I don't know that we need it. If we have that same language we have in other provisions, that might work here.
I think the other thing to keep in mind on this section is, as an institution, you don't, not in my experience, you do as a responsibility under Title IV have to ensure that anyone that you're contracting with has not been debarred, or there's rules about who you contract with because of as it relates to Title IV. But otherwise, an institution wouldn't generally be asking, unless it was public information, right, where an OPM or some third party has reached a settlement agreement that becomes public. An institution isn't going to know if they settled a civil litigation with employees or something. Even if it would potentially fall into one of these categories, it may be confidential, and it may be something that the institution would have no idea about, and the contractor has no intention of telling you about. So I think that's another, I don't think that necessarily it has to change how you're approaching this, but all the stuff we just said notwithstanding, but just keeping in mind that you're basically asking an institution to be accountable for what a consultant or contractor has done, even if it has nothing to do with them. And so that, might be more difficult for them to know and to get.
Yeah, I sort of, I'm sorry, I was thinking out loud. I'm fine if it just has the same language as in the other provisions that talk about violation of consumer unfair business or fraud, whatever the language is in the other provisions, and not deal with employees specifically. I did have a couple of technical things on a couple of the other parts when we're done with 5. Are we ready to? Can I go back to a couple of the other parts of Section 8?
Sure, go ahead.
Okay. On number 1, I think what happened on number 1 and also number 3 is I think this language is drawn from language in the statute that has sort of similar language that can be used in a whole bunch of different places. But in taking it from the statute, it kind of messed up the grammar a bit. So I think it has the institution had its authorization revoked, suspended the 5 years before submission, and then where it starts out was subject. Your sentence starts has the institution, and then you're going was subject. So yeah, I think it needs to be has the institution or has the institution been subject to an enforcement action? So it's just a grammatical thing to fix that. And the same thing in 3. Is the institution currently on probation, show cause, subject to other adverse action, or the equivalent by its institutional accreditor, by a programmatic accreditor, or, and you start the sentence, is the institution currently, so, or has, it's not clear who has is, or so it should be, or has the institution had its just to make it a little clearer and be grammatically okay.
Okay, thank you.
Regarding number 6 and the reference to borrower defense repayment claims, should be clear that the department does not generally communicate or when it receives borrower defense repayment claims for the institution unless they reach out to the institution for information related to a specific claim. So there isn't currently a notification process or any sort of required notification. There were some information came out in Freedom of Information request recently in that regard, but I don't know, unless they've been contacted by the department to supply information in response to a claim, institutions wouldn't give you a fulsome answer to 6 because they wouldn't have access to that.
So by saying the number of known borrower defense claims, we recognize that it's not going to be a complete picture.
Correct. Correct. Yeah, that's the point. Yeah, if that information you could probably get from the department, but you wouldn't be able to get it from the institutions. But you're right, Margaret. It's qualified with known, so it would work as it is. Just don't expect that that's going to be a complete number.
And I gather from what you're saying, you don't think there really is a way that that information would be available.
Absent getting it directly from the department, I don't believe so. No.
Does the department give that information out to institutions if they ask for it?
No.
Yeah, okay.
No, until the department sends the school the here are all of your borrower defense claims, defend yourself. The school doesn't know how many there are. They don't know anything until the department tells them.
All right, so probably it's fine the way it is, saying the known number.
You know, I think one thing that was in our considerations as a staff on this one was just the fact that the borrower defense rule has been in flux and it will continue to be in flux for a little bit. So I think in terms of what colleges will know or when they'll find it out, there's kind of what's the status quo and what we might expect going forward. Kind of use the known language, attempting to stay flexible, knowing that we don't know what's coming.
Yeah, that's a good point, Debbie. And also, each of those eras exists discretely. So when that rule is changed and then changed and is changed back, each of the students within those cohort periods are under the rules that were in place at that time. So it's even more complex. It's not like a new rule will clarify the past because it will remain discrete.
Are we ready to talk about part 7 of section 8?
Yes. And so in that section, we're asking that this institution document the number of known student or employee complaints against the school concerning consumer protection or unfair business practices or fraud filed with a governmental agency or nonprofit private organization that receives such complaints, such as the Better Business Bureau, during each of the most recent 5 years available. And we're asking that they provide a brief summary of each complaint and its resolution, including how much, if any, was paid to and for the student or employee, for the institution as a whole, and for California residents enrolled.
Again, on this one, I think just a grammatical issue. I think if you take that last clause and put it at the beginning, it would probably read more clearly. So that it would start, for the institution as a whole and for California residents enrolled, comma, document the number of, and then everything else stays the same.
But is the institution as a whole already in includes California residents. So are you asking them to break them out separately, or?
Yes, specifically we want to know what's happened with the institution, and then we want to know what happened specifically with the California residents.
Okay.
Students, sorry.
And just on that same note, it says for the intuition as a whole, just a little minor typo. But yeah, so I'm fine with what Margaret suggested. I would say maybe for the institution as a whole and separately documented California residents or something like that. Because reading this, I'm thinking, when I read it the first time, I was like, the institution as a whole would include California residents. So what does this mean? So I think you just need to kind of make it clear that you're asking for the whole and then separately the California. So I think Margaret and I are kind of saying the same thing. My other issue with this is I don't have an issue with the government agency, and I don't know if anybody else is in this committee has had to experience working with the Better Business Bureau, but I personally would not. I don't know. I mean, I've seen some crazy stuff with them. I've seen complaints that are complaints that they make about a school or about a company that aren't even really about the company, or that they just like they're like Yelp reviews. And so I don't know. I struggle with validating some of that. I mean, I have if someone files with a government agency, I have no problem with that. But to me, that is not the same thing as filing with the Better Business Bureau, where we have no real understanding of what their process is or how they handle stuff. And you're not generally resolving something with them the way you would with a government agency. What other nonprofit private organizations would we think would be having a direct receipt of complaints that the school would then be responsible for responding to, right? Because school doesn't ever have to respond to a Better Business Bureau complaint either. They're not required unless they're a member. So I guess I just don't agree that should be in there, because the school doesn't have a responsibility to comply with those things. They do have a responsibility to comply with laws and regulations that a government agency would have oversight over. But so anyway, I'm just putting my 2 cents in there that I think that whole nonprofit organization, Better Business Bureau stuff should come out.
Kate, I would concur in the strongest terms with that. I agree 100%, and would add my additional 2 cents.
I have a little different view. First of all, this isn't really, it's not really dinging the school because there are such complaints. It's just wanting to know what's out there. And it does allow the school itself to summarize what the complaint was and what the resolution was, so that if it was a crazy complaint, they can certainly, explain that in a sentence or a paragraph, or probably a sentence. And if the resolution was, no resolution because it was a crazy complaint, they can certainly say that. The reason I think it's important to include something like the Better Business Bureau or other things like that is when you look at studies about what consumers do when they're dissatisfied, the vast majority have no idea where to file an official complaint with some government agency. And most people have heard of the Better Business Bureau. And if they get upset, I'm going to file a complaint with the Better Business Bureau. And so you may find a lot of stuff at the Better Business Bureau, even if there aren't that many complaints filed with a government agency. It's not to say that what they do with them by any means is valid or invalid. I mean, I sort of have the opposite reaction, which is, we've sued some companies for fraud that were still rated, AAA by the Better Business Bureau. But I do think that at least lets you know what's the universe out there of complaints, and you can look at them and see whether they make any sense or not. So I don't see the harm in it, and I do think it lets you get a tiny bit larger piece of the tip of the iceberg, because most people who are dissatisfied, the vast majority don't complain, and if they do, they complain to somebody that really can't help them often.
The harm, if I may disagree, Margaret, would be the administrative burden and administrative complexity of a school that has thousands and thousands of online students across the country, taking an area that they do not have to document. Like if they've responded to a state agency, or if they've responded to a formal complaint process with a student, to Kate's earlier point, they would have records of that. It's highly unlikely that they would have organized records about every Better Business Bureau complaint that was made, many of whom, again, maybe aren't even students, don't have any real business relationship with the school, haven't been a student of the school. They just typically are not going to be in their tracking system. And so the administrative burden for them to try to report on those and write a narrative summary of each of them is unreasonable.
I agree with Joseph on this one because and I was going to say exact same thing. You're talking about an out-of-state institution that could be doing business in 50 states, and you're asking for Better Business Bureau complaints in what it would essentially be 50 states. And if you're not a Better Business Bureau member and you're not paying attention to a Better Business Bureau rating and somebody files a complaint about you, you probably would ignore it. And so, or never hear about it at all. So you would essentially be asking an institution to do a 50-state evaluation of whether or not they receive Better Business Bureau complaints. That, I mean, it's just, I feel like it's unduly burdensome. It's one thing for, stuff that schools already have to report. They already have to comply. They already have to document. I don't have any problem with them having to report that to the Bureau as part of this, but I think we're asking too much to expect an institution to provide that level of detail, especially system-wide, from a non-governmental organization that they have no responsibility to even respond to.
Just one clarification. Sorry for there's some background noise here. I can't stop it. But my experience with the Better Business Bureau is that they forward all complaints about a business to where that business is located. So that if you have complaints coming into the local Better Business Bureau and the company is located elsewhere, they get forwarded to that location. So they're not really scattered all over. The other thing to keep in mind too is this is phrased again in the terms of known. And finally, again, my experience is most companies are pretty well aware of Better Business Bureau complaints. So I don't know. And I would be astounded if there would be that many filed unless it was a really, really horrible school. Like, how many complaints would there be against a typical school that you're aware of, Kate? I mean, it can't be that many.
I mean, I think that's the problem is you really just don't know. And that's why I'm saying, like, it's one thing to ask schools to provide information on reports or complaints that were given to some agency that they had to respond to. That's something they probably track. But, an institution may get Better Business Bureau complaints and because it's like getting a bunch of Yelp complaints. Like, do you go in and respond to all of them? Do you need to? I just don't know that that's the best. I understand what you're saying, that you're hoping that we'll get an indication if there's like systemic issues, and that this might be a way of documenting it, but I don't necessarily think that they're going to be credible or useful for that purpose anyway. And you're asking the institutions to do, to provide information that they would not have readily available, which is already, a tough call. So anyway, I think you've made your case. Joseph and I have made our case. I don't know if anyone else has an opinion on this particular issue, but we'll have to leave it to the Bureau to determine in their discretion whether or not they think that it's appropriate, given everything else in the application.
That sounds fine.
Okay.
Thank you. Appreciate your comments and your discussions on these topics. Okay, the last thing we have is we did change the number on section 9, which was just a numbering issue. So we added section 9 for certification under penalty of perjury.
You'll probably have to change again if you're going to make the Title IV section its own section. So
right,
that will be 10.
Yes, and that would be all.
I have kind of a broader, this is Melanie Delgado. I have kind of a broader question about this form. I appreciate that the Bureau added all of these requirements. I think that's good. I'm wondering why they didn't go farther, because when I was looking at it, one suggestion that the absence of which kind of jumped out at me, for just one example, is the absence of any requirement that these institutions provide any documentation of the cohort default rate, for example. And the cohort default rate, as you know, measures the student's ability to repay their debt. And I think that would be something that would be valid to look at, to consider in the registration process. And I'm just wondering if there are any other suggestions. I saw there were several really great suggestions that particularly Margaret Ryder submitted that were not included, and I think would be important to the registration process. And I'm wondering if there's any way that we can hear about what those suggestions were and why they were denied, or why the Bureau decided not to include them in this form, because I really think that you could go farther than you did with the requirements that you included. Thanks.
Yvette, would you like me to take the first pass at that one?
Sure.
That's great questions, Melanie. I think, we did get comments from a number of advisory committee members, including Margaret. We went through as a team internally all of the comments that we got. And I would say, broadly speaking, it was we felt like the intent of the bill was to help the Bureau identify schools that would be high risk to Californians, and therefore where we might want to consider the risks to Californians in their registration. Obviously, the broader part of AB 1344 is not just about this form, but allowing the Bureau to potentially condition or even deny a school's registration. So that risk part is really key. We tried to walk a line of kind of what was really clearly tied into risk, particularly timely risk assessments that we might be able to get, as well as burden on institutions, questions like viability, of course, were front and center. There were some of the comments that, we would love to get, but when we looked into it, realized schools wouldn't be able to get that for us, so not worth putting it in that form. One of the things that on the cohort default rate point in particular, and I think if folks want to provide to us suggestions that of things that we really should take a second look at, we're more than happy to hear that. One of the things that was that we grappled with quite a bit is, to what extent did the law, AB 1344, allow us to use information to inform our decisions about potentially conditioning or denying registration that was out in the public, that was public information, that was not something we required colleges to report. In that, from the point of view of having colleges report to us a bunch of information that's already available that we could go find out on our own, we had some mixed feelings on that. Ideally, we would be able to use publicly available information in our determinations, but it looked like the law didn't allow us on that to do that. So that's something that we're definitely thinking about. If the advisory committee members think we might have more flexibility on that, that would be useful information for us to take back and take another look at. And again, if there are other particular components like cohort default rate, repayment rates, of course, these loan repayment measures are going to be quite impacted for a number of years to come, given the federal student loan repayment pause. But whether it's those or other measures, we're happy to take another look if folks think that there are glaring omissions here.
This is Margaret. I do think that there were a few things that I had suggested that were not included that are important. And I know you've already had a chance to look at those, but if you are taking a second look, I would just ask that you take a look at some of those things that I think can be critical. For example, one that is often an indicator of issues, and again, it's just to, so that you have a sense of what the school is that's coming in, is what percentage of their revenue they're getting from various financial aid programs. Also, a better sense of what the local agency does to look at them, as far as, do they do inspections or not? Do they require reporting, or does their accreditor require reporting of completion rates or placement rates like we do in California? Some of those things that suggest that a school could, I think, as Joseph pointed out the other day, the states are very different. It would be helpful to understand, is this school being looked at carefully by the other state, or do we need to pay more attention to it? Should we allow it to be registered here? So I would just ask you maybe take a second look at some of those. And, I'm sorry, and the other one is, I think the percentage of enrollees that are distance students certainly used to be a good indicator or something to look at carefully. I mean, now with the pandemic and everybody doing online, that may not be as significant, but because there tends to be more difficulty in monitoring those schools, I think that's something that it would be helpful to know what percentage of their enrollments are actually distance.
Are there other ideas for things that we might want to, give it another look at? Otherwise, you've definitely given us a lot of food for thought, a lot of next steps on our end in terms of how to move this along.
Thanks everybody for your input. Does anybody else have any discussion points for item 6? Otherwise, I'll open it up to the floor. Yvette, did you want to say something?
Okay, Kate, I was just going to get in really quickly and just say there was one other, I don't think that we can discuss it if folks are interested in it, but we did include one other very brief memo in the packet, another aspect related to AB 1340 and the labor market outcome reporting. We've got a lot of tracks of work underway with respect to implementing AB 1340. Obviously, we went over the draft regulations. One other thing that we're already looking ahead to is kind of once we get the data, once the data is collected and it's reported and it's matched with EDD, what's the output there for students with respect to our website. So there was a summer fellow, Caroline Siegel-Singh from the governor's office, who was able to assist the Bureau in just tapping into the expertise of some key stakeholders for just to get us starting to think about what that eventual output will look like. So, there's just a couple takeaways. There's no imminent decisions that need to be made there, but did just want to share with the committee what we were doing along that track as well. And thank you to the members of the committee who helped us think through those questions.
Great, thanks, Deb. Anything else on this agenda item for the committee? All right, moderator, can you open the floor to public comment for item 6?
This is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click that Q&A icon located at the bottom right-hand corner of your WebEx screen. All right, it looks like we do have one individual who's requested public comment. One moment. Individual identified as Robert Johnson. Robert, you'll be given 3 minutes to speak and a 30-second warning. I'll be requesting to unmute your microphone now. All right, Robert, you are unmuted.
I'd like to point out probably something that has been circling in the room, but as the Bureau marches on to kind of financial extinction and the fact that its finances are not sustainable strictly on annual fees, there's no calculation that gives the state $22 million to continue to administer the oversight of the program. This is a great example in this item 6, where I doubt seriously if anybody has considered for the fact that if the application fee is $1,000 or $2,000, is that matched equivalent to the staff time essentially building in to review these kinds of applications? I cannot imagine that the Bureau will take less than 1 year to look at this application and approve it. Right now, the full approval is about a year, 420 days for some. The amount of information that you need to process as part of the Bureau's review of these requirements that you're adding is enormous. And if you're looking at billing on an hourly basis, there's no way you can justify a $1,500, $2,000 fee compared to the information that you're asking the school to provide, which you have to review as part of the Bureau's job. It isn't just the school that's going to basically have to do the work. The Bureau is going to have to review this information, which is often a judgmental call. So it will take time. And I don't think anybody has looked at this, which I think is a great shame and indicative of where the Bureau has had over the last 10 years in doubling the staff from 60 to over 100. Thank you.
All right, this is the moderator. We will move on to our next individual who has requested public comment. Individual identified as Angela Perry. Angela, you'll be given 3 minutes to speak and a 30-second warning. I'm requesting to unmute your microphone now. All right, and you are unmuted.
All right, thank you so much, moderator. Thank you so much, members of the advisory committee and Bureau staff. I wanted to again say thank you for this update. I think everyone on this call knows how enthusiastic I am about these two pieces of legislation and getting them put into regulations and enacted. I am thrilled that 1340 is moving forward and would echo the discussion from earlier. We can go even further. There is more information we could collect that would be really valuable both to the Bureau and to students. I am especially excited that the Bureau is going to start having more data available to the public on their website, and that the Bureau and the Governor's Office have been thinking about what that information should look like and what information is valuable to the public. All of the public segments already report this data. It will be part of Cradle to Career. And so I am enthusiastic about that data collection and really looking towards more that we can do, more that the Bureau can collect and more that it can report. On 1344, I definitely, again, I would agree there are more elements that we can look at and more things that we can collect. I hear the concerns about collecting information that the schools don't have, but do appreciate that the language in the regulations specifically calls out that it's looking for known complaints. So that should not present a huge burden. The statute or the regulations are looking for the information the school already has. And I agree that there are, I know I mentioned it earlier, complaint systems unfortunately do not typically serve students well. And there is information out there that the Bureau can and should be trying to tap into where it's possible to try to get a more complete picture in order to support students. And then to answer that last question, I believe if I remember, the last comment, excuse me, I believe if I remember correctly, there is something in the memo about the online out-of-state registration fee and the need to assess that in relation to the workload. And I would just say that TCAS definitely feels that pressure, that
30 seconds,
and would really look forward to any opportunity to being able to support the Bureau in being fiscally supported and fiscally able to have the capacity that they really need to address these and all issues. So thank you again for the opportunity to comment.
All right, this is a moderator. We'll move on to our next individual who's requested public comment. Individual identified as Rachel Bolcher. Rachel, you'll be given 3 minutes to speak and a 30-second warning. I am requesting to unmute your microphone now. All right, Rachel, you are unmuted.
Good afternoon, Chair and members. My name is Madeline Cooper. I'm filling in for Rachel at the moment, and I'm providing comments on behalf of a group of psychoanalytic institutes operating in California. These institutes provide psychoanalytic education and enhanced training to licensed psychotherapists, where all of their students are licensed professionals. In addition, the institutes charge very low fees and operate with very small budgets. The staff at most institutes is all volunteer. The professors and other teachers are professionals who commit to teaching and mentoring other professionals who wish to deepen their knowledge. Excuse me. The psychoanalytic institutes have relied on the verification of exempt status in existing law to provide their services. Only one institute in California has sought and obtained full approval as a private post-secondary institution. Unfortunately, in the last few years, the BPPE has been less than consistent in its review of applications for the statutory exemption, which has left many of the institutes in a state of limbo relative to their authority to operate. The status of exemptions has been a subject of the Sunset Review, and we have been engaging with the legislature during the Sunset Review process to address our issues with the exempt statute. However, as you know, the Sunset Review has been delayed for 1 year. Therefore, we would encourage the BPPE to ensure that the regulations regarding exemptions are consistent with the process and that the issue of the exemption application process continues to be addressed through the advisory committee. Thank you.
All right, this is the moderator. It appears that was our last request for public comment. Would you like me to close the Q&A panel?
Yes, thank
right.
you. All right, moving on to the next slide and the next agenda item, which is the update and discussion on Senate Bill 118. If you all recall, we had a brief discussion about this the last meeting, specifically just kind of discussing some concerns about how this would work for institutions that have programs where the outcome is often impacted by criminal background situations. And so the Bureau was kind enough to do some research on this, and there is a memo in the materials reflecting what they came up with. So I will open the floor, I think probably to Debbie to talk about this one. Debbie, if you're speaking, I can't hear you.
Thank you. It would be good to unmute myself. This was I thought it was a very interesting conversation that was had at the last meeting that we had about SB 118, which was signed into law in 2020. That bill restricted a school's ability to inquire about an applicant's criminal background for use in the admissions process. And I think there were some shared concerns across a lot of the committee members about that. And, you know, given the importance of that to consumer protection, we wanted to take that on and just do a little digging ourselves. The way we try to operationalize our research on that was by posing the question, can schools reliably predict the impact of criminal backgrounds on future employment opportunities? Because if they can, then placing conditions on admission or enrollment helps the students. If you can't reliably predict, then it might not help the students. When we had the discussion, you'll recall that we asked for examples of particular fields and careers that were of concern. And we heard nursing, pharmacy, security guards, and then we talk a little bit about truck drivers as well with the insurance aspect. I think, in brief, I know this has been a long day. I won't go through all of it, and I want to save most of our time for any discussion folks want to have. I think what we as a staff learned is that SB 118 was really part of a much broader set of legislative changes that the state has been pursuing over the last few years for criminal justice reform. The biggest one that impacts this question with respect to the discussion we had at the last meeting was Assembly Bill 2138, which was passed in 2018. And that really restricted the ways in which and the timelines in which licensing entities could use criminal history or convictions in making licensure determinations. It was restricted to 7 years and a much more narrow array of activity. We then took that and followed up with a number of the other implicated boards and bureaus under the Department of Consumer Affairs. I should give a shout out and thank you to all of the boards and bureaus who were very responsive in working with us on this. And in brief, what we learned is that as it pertains to actual licensure outputs, we did not believe that it would be. It was clear that you could predict who would or would not get a license. In fact, across all of the boards and bureaus that were referenced in our discussion at the last meeting, the vast majority of applicants to those boards and bureaus with criminal backgrounds still did receive a license. So we have the statistics in there for 4 of the other DCA boards and bureaus. The one notable exception, again, that did come out up at our last meeting was this question around truck driving schools and whether or not folks who had a DUI or a DWI would be able to get fleet insurance, which was a requirement for getting a job in the trucking industry. We spoke with 2 different truck driving employers or truck driving companies, asked them about this situation. What we heard from them is that they, of course, they're not governed by the same state laws that DCA boards and bureaus are, but what we did hear is that they had an internal process that sounded not too dissimilar from what DCA boards and bureaus are doing, and they also said it's very rare that someone, even who comes to them with such a conviction, is not able to get the requisite insurance and thus jobs. So, our conclusion. But we certainly know there's a lot of other aspects to this question, but, again, we were looking at the predictability of licensure determinations, and I think our research suggested that there really isn't a reliable way to draw a very clear and predictable line between criminal history and eventual licensure outcomes in the fields discussed by the committee members. So happy to take any questions. I think we learned a lot as a staff going through this. Helped certainly me as a new bureau chief learn a lot more about the DCA boards and bureaus. So thank you.
Yeah, this is Margaret. I have a comment. I understand the statistics, which says that basically this applies to very few people. What the boards and bureaus, at least the one I looked at was the Security Bureau, did not say is that nevertheless there are still certain crimes for which a license cannot legally be provided. So for those individuals who fit that narrow criterion, they would definitely be refused a license. It's not a discretion. And I sent to Richie earlier the language on this, but I can just read the pertinent part. For this is for the Bureau of, what is it, I don't know what the security guards basically are under it. It says, before an application for a license, registration is granted, the applicant or his manager shall meet all of the following. And then one is be 18 years of age, and the second one is not have committed acts or crimes constituting grounds for denial of a license under Section 480. So they can't have committed any crime or act that would constitute grounds for denial under this other section. This other section says a board can deny a license if they've been convicted of a crime or subject to a formal discipline only if either of the following conditions are met. And then the relevant one here is the applicant was convicted of a serious felony as defined in section such and such of the Penal Code, or a crime for which registration is required pursuant to section such and such of the Penal Code. So you putting those 2 sections together, shall meet all of the following, not have committed acts or crimes constituting grounds for denial. And then this other section says there's no grounds for denial except within the prior 7 years, the applicant was convicted of a serious felony. As I read those 2 together, I think that's an absolute prohibition on those individuals who meet that more narrow description. So while in most people who have committed a crime, yes, could get a license, there are some within those categories who would, there's no discretion, they would be denied a license. So I think this issue is still there. It applies to a much smaller pool of people, I think, than we initially thought. But I don't think that this really resolves the issue in those circumstances where you have somebody who's committed one of those particular felonies and is then signed up to take a class to get a license and has no chance of getting that license because it's prohibited by law. So I think there's still an issue affecting people, but a much smaller number of people that I'm afraid, I would like to see, rather than saying statistically, so many, it's not a very big deal. I'd like to know, are there crimes for which a license has to be denied? And I may be reading this wrong, so maybe if your legal looks at it, they would come up with a different conclusion. But the right way I read it, in those particular instances, they cannot get a license. And so, I don't know, I still think it's an issue for us.
This is Joseph. I'd just like to thank you, Debbie, and staff for your diligent follow-up on this issue. I appreciate it. I was one of the people that had raised the question originally, and appreciate the diligence and the thorough review. As I share still some concerns, some limited concern, as Margaret mentioned, but I appreciate the work and the guidance provided by the Bureau. And also recognize, as I think all of us on the committee should, that indeed it's part of a larger social change that's been going on over the last several years. And so it is an opportunity for us to progress in that sense. But it is probably something that we'd want to keep on our radar over these next several years, because a lot of one of the things that's happening here is schools are restricting already, and therefore there are fewer applicants coming through these licensing boards, or fewer graduates seeking employment in these areas. And so opening schools to enroll more students with these troubling convictions will increase the volume of graduates that are then seeking these licenses and employment and so forth. So it's something that we'll need to keep an eye on over time.
Thanks, Joseph. And I would just add I think the other, first of all, thank you, Debbie and team, for doing this, because it was really helpful, additional sort of context to kind of narrow the scope of maybe what we perceive the issue versus maybe how often it really does come up. But I think from the institution side, and Joseph, I'm sure your team has already kind of thought this through. Of course, I've had lots of institutions who want to comply, and they're trying to figure out how to make sure students understand at the front end that if you're enrolling in this program, we are not going to ask you about your criminal background because we're not permitted to. But you as a student need to understand that you may have trouble. You may have trouble getting through this program because our clinical partners, have background check requirements, or housing might have requirements, or there's things that may be out of the school's control that might still be problematic for the student. We need to be sure as institutions that we're fully disclosing this to students, because the result on the school end is the risk that you are burdening students with debt and wasting students' time, and to not know that this is a problem, and the student doesn't say anything, and then all of a sudden you can't get the student through a clinical, and they've already spent 50 grand to get through the core of a nursing program, and no clinical site will take them because they're a sex offender. That is a real issue for the schools and for the student. So we just need to be aware, because I am fully on board with the idea of people who have been charged with crimes should not have the rest of their lives basically forestalled on any progress. I mean, I think this is a wonderful idea. We should be, as Joseph said, we're progressing in the right way, but it's still, as long as there are other things that can impact the students' potential for success, we need to make sure on the school end that students understand that. Because I think even if the numbers are not as big as maybe we thought they are, there are still situations where, if we don't know that a student has a criminal conviction, that will impact them. And the school won't know that. The student won't know other than what we disclose to them. So being fully, disclosing this is important. The other thing, this is really more of a, pontification at this point, because I don't know if there's anything we could do about it, is institutions have to report, crime statistics, students that are Title IV, through Clary Act and that kind of thing. And I think one of the other issues that this kind of raised for me was a lot of institutions use this process as a way of making sure that they're not creating a dangerous campus community. And so if they have somebody who is, like Margaret was pointing out, if you have somebody who was convicted of a serious felony, like a sex assault or murder or something like that, one of the ways that institutions would use that information is to say, this creates an unsafe community. And so, we don't want a person who just, we don't want John Wayne Gacy at our school. There are situations where it's also a campus safety issue. And so I think that may come up a little more. That's not really in relation to this, particular conversation, but I do think that it's another thing that institutions need to be thinking about, is if they're not going to have this data, then they're just gonna have to be more aware and more careful. So anyway, the research you guys did was super helpful, but I think Joseph and Margaret both pointed out that there's still going to be a lot to deal with this, because it is going to create some challenges. So I'll stop. Does anybody else have any comments or discussion or questions on this one?
I'd say, I didn't say initially, and I think Joseph reminded me, yes, I do really appreciate the amount of effort that was gone into researching this, and what that did is it definitely narrowed the field of those that may be impacted legally, which I think, even though a smaller number, we still need to deal with that issue. And I appreciate the comments that even though legally a lot of people are not going to be prohibited from getting a license, I can see from the school's point of view that there are still lots of issues. And if you have legitimate schools like, the ones that Joseph and Kate are talking about, they're going to make sure they do a good disclosure. And so I guess for us, the question is as to those people who wouldn't be absolutely prohibited. So the only way you can deal with it is by disclosure. Maybe we need to take another look at what we require along those lines. And or maybe think about whether there should be something on the website of the Bureau or in OSAR's presentations that deals with some of those issues, just so that students are sort of forewarned.
Thanks, Margaret. Anyone else? All right. So with that, moderator, I think we can open the floor to public comment on item 7.
This is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click that Q&A icon located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, looks like we do have one individual has requested public comment. Robert Johnson. Robert, you'll be given 3 minutes to speak and a 30-second warning. I'll be requesting to unmute your microphone now.
Yeah, thank you.
And you are unmuted.
Thank you. As an association that represents all kinds of schools, years we've had some fairly epic battles with licensing agencies in the state about this very issue. And 2 comments. One is that typically the person who reviews the licensure application is the person that has the power. And typically some of those are very strict. One example was for pharmacy technicians, which I don't know if that was surveyed. For a considerable length of time, the department said that any arrest was disqualifying for licensure. Not conviction, just arrest. And that was a big fight. I'm not sure we won that. So it is that while officially the department may respond one way, the only real way to tell whether or not people are being denied licenses is talking to the actual people that do it. And often you'll find that's a different lifestyle than it is at the top. So I would just say that from a school standpoint, if you're going to promote a policy of anybody gets in, you can't ask them, then there should be a corresponding non-liability on the school institutional part if they do take the fees for and they can't get placed. There should be some equalizing policy in that if that's the way it's going to go. Thank you.
All right, this is the moderator. It appears there was our only request for public oh, I apologize. We do have one more request for public comment. Individual identified as David Wells. David, you'll be given 3 minutes to speak and a 30-second warning. I will be requesting to unmute your microphone now. All right, and you are unmuted.
Training program approvals for the county EMS agency under EMS division. And our concern is just we've been having a great working relationship with our primary training programs. However, these programs cost anywhere from $1,000 to $7,000, and their program's 170 hours. And there's certain requirements in there that prohibit somebody from being credentialed as an EMT in the state in California. And then there's those gray areas. And we have a great working relationship with our programs overall, I believe. I don't know if that's throughout the state or not. I mean, we hear most of it, but the challenge would be if they can't inquire about it and direct them, we encourage all our programs to provide them with the information to contact the local credentialing, but we don't have the rights to investigate somebody prior to see if they would be credentialed, because it's prohibited by us until they submit a complete application and background, and they can't do that until they complete a program. So I'd err on some caution as encouraging or requiring the private post-secondary programs from providing the information that could preclude them, as well as the contact information, to a credentialing body to give them some guidance so they can make their own determination whether they're going to enter that program, because these programs are relatively short. They're done in 5 weeks to 17 weeks and only 170 hours of training. Thank you.
All right, this is the moderator, and it appears that that is our last person to request public comment. Would you like me to close the Q&A panel at this point?
Yes, thank you.
All right, the Q&A panel is now closed.
And thank you for those comments. Those were helpful context as well. Okay, so moving on to our last substantive topic, which is item 8, discussion on the Bureau's strategic plan, framework, and goals. And I assume this will be you, Debbie, so I will open the floor to you.
Thank you. Yes, that is correct. So just as a little bit of context, the Bureau's most recent strategic plan expired in 2020. So this conversation is overdue. In fact, the Bureau began working on a strategic plan refresh back in 2019 and had done pretty extensive work on it before COVID, and then eventually leadership changes slowed things down. So since joining the Bureau myself, I've been able to pick up a lot of that work that was done already and then use it as the backbone of literally dozens of internal conversations to better understand where the team thinks we should go, where we've been, and also to inform my own opinions about that being new, about 4 months in at this point. So I'm very happy to be able to share with you today, kind of where we are at this point for your input. I think once we finalize our goals, the next step will be for the staff to come together around concrete plans to operationalize them. Just sharing this a little bit because I want to put kind of this moment in time in context. We're very well aware that a goal without a plan to achieve the goal is just a hope, and hopes alone are not going to get us where we need to go. So the Bureau's leadership and management has been already thinking about how to operationalize each of the goals that are in the document that was in the packet, and also how to measure our progress. And we're pretty excited to move more in that direction at a more kind of internally focused stage once these higher order goals are finalized. So I think at this point, we really welcome feedback on the language that we've shared, any specific, whether big picture, small picture ideas or suggestions on where we should be going, again, including specific steps you might suggest that we want to consider to achieve all the goals as we get to that next stage of the work. So with that, you can really open to any feedback on any of the pieces or any of the components that are in the document shared.
I have a few comments. Surprise, surprise. This is Margaret. Just a kind of a technical thing on goal 2, enforcement, protect the interest of students, consumers, and so forth, taking enforcement actions when necessary. I think it should be when warranted, because, enforcement actions are never technically necessary, but it's really when they're warranted. Going back to the mission statement, I think it would be important, if we're going to have a mission statement, that it starts out by reiterating the statutory language that the Bureau's highest priority is to protect the public, and then proceed with, we protect the public, so forth and so on. And as to the points under the goals, I've always had a problem with these strategic plans because, as having been a teacher in adult school, a goal is, as you say, nothing but a hope unless it's measurable. And most of these are not measurable. It's sort of like me having a New Year's resolution to lose weight. How does one measure whether I've accomplished that? Compared to having a New Year's resolution to lose 5 pounds by July 1st, and another 5 pounds by December 31st, or whatever it is. So I think that either here or, I mean, this time, since it's behind, maybe we don't manage to do it in the public-facing document, but certainly internally, I'd like to see a lot more specificity and just give some examples. I don't know if I have some here that are. If you're talking about inspections, for example, one goal that leaps out at me would be to specify how many you intend to increase per year and by what year you intend to reach the statutory requirement for the number of inspections. Because I think we still are quite a ways away from that. I realize some of these goals are very difficult to set right now with, things being half shut down and so on. But I think that's an example of the kind of thing where there needs to be more specificity. Also under enforcement, a goal would be to take certain steps to establish relationships with other agencies so that the work could be coordinated or shared. For example, to attempt to establish a contact person at the following agencies, so that for example, a cosmetology program, if you don't have already, establish a contact with enforcement there, and then determine whether cases could be worked on jointly. Same thing with district attorney's offices, attorney general's offices. A goal maybe to reach out and try to secure speaking engagements at their staff meetings so that you can, develop those contacts. I don't know that these specific things are it, but I do just think they need to be a lot more specific. As for complaint handling, we've talked about the high number of non-jurisdictional or unsubstantiated complaints, and some type of, internal audit or bringing in some outside people from student groups or other agencies to review a sampling of those to determine whether, in fact, even though the complaint seemed like it was somebody else's jurisdiction, whether there are aspects under the Bureau that could be worked jointly, or that your work could then facilitate whatever their work is on the other aspect. So I would like to see a lot more specificity so that you can measure it and see if you did meet the measurement. Because right now, I don't think there is a lot of anything much that you can measure here. So that would be my recommendation. And I recognize, you're coming in with something that's already been pretty much formed. And if you've attended meetings before, you've heard me make the same complaint about the strategic plans in the past. I think they really need to have meaning. They need to have teeth. And I think there's a need for a lot more of that here.
I would just add, first commend you for the good work to continue the foundation that was laid before and to articulate a clear direction going forward. But I would add to Margaret, or emphasize the need for measurable outcomes, and just encourage you to, I think there's enough substance there for you to come up with some specific measurable or strategic measures that would determine your progress along those. And so add that into the strategic plan. The previous version did not have measurable goals, and I would encourage you to add that in this iteration.
Thank you for the suggestion. Joseph, do you, Margaret's ideas for, And again, we will definitely take all the feedback, back and figure out what goes in this document. What do we kind of bake into our workloads and plans? Margaret's examples of where specifically we might want to go were really helpful. Do you have some that come to mind for you that feel like areas where it is most important that we really hold ourselves accountable for making measurable progress?
Actually, Margaret brought up new categories that she feels are important to her, which I recognize and respect. I think you have the basics in your current draft. I would just encourage you to articulate them. So what is increase as measured by, or improve as measured by, and so forth. So I think your language is right. I just would encourage tactical measures for them.
And the one thing that I would add, Deb, that is sort of overarching, I don't really see in here, is I always think about, like, if you ask an accreditor, what are you doing? Part of their job is obviously providing quality protection for students, but it's also working with institutions to make sure the institutions are doing things the right way. And so there's a lot of focus on sort of the compliance piece, but I think there should also be some focus on sort of continuous improvement with the institution. So the ways that the Bureau is providing training opportunities, and there's some mention of these things in here, but they're not like really sort of coordinated to the same, sort of goal of making sure that institutions understand their responsibilities and that the Bureau is sort of in a constant state of ensuring institutions are doing their best, like they're the best they can be, right? So trainings on all the different compliance elements, consistent communications, some of the things that we've talked about before about just making sure that schools are getting consistent, clear guidance on how to comply, so that it doesn't always feel like a cudgel and more like, we're helping you on the front end so that we don't need to beat you over the head at the back end. So I think there could be a little more focus on that as part of the overall goal, because to protect students, you need the schools to be good, and good schools, need help to be good. So if there's some piece of that you could tie in, I think that would be helpful.
Real quick, I can articulate a couple examples of what I mean by a specific measurable goal. Under Goal 1 Licensing 1.1, the goal is to streamline applications to facilitate a swifter licensing turnaround. And so earlier you referred to the 421-day average. So achieve a 2022 average of 300 days or 250 days, or pick a target, an achievable target that incrementally improves over time, or your OSAR, like Consumer Education and Support 5.1, expand statewide awareness of the OSAR, achieve a 10% year-over-year increase in participants in OSAR workshops, headcount of participants, things like that.
Anyone else have any comments on item 8 from the committee? All right then. Thank you for sharing this draft with us, Debbie. If the committee members have any additional thoughts or want to make suggestions, is this something that they should just email to you, or what would you recommend as next steps?
I think that would be great. Maybe we would set another, I think for the last meeting when we invited comments, I think we set something around 10 days or so. Maybe if we wanted to say by the end of next week, if that would work for folks, if you wanted to submit any sort of more specific or, additional suggestions, let's call it that, because again, we're, open to suggestions, however big or small. On the one hand, we are late to this, and I know, again, I think folks are really interested in kind of getting to that next stage, which sounds like the same stage that you all are interested in making sure we get to as well. So I'm just really interested in making sure we're getting out the right types of goals so we can work towards operationalizing them sooner rather than later. So would that work for members to submit some comments by September 3rd if they have further comments, and you can send those to Richie.
Yes.
That is great.
Sure.
I haven't heard any dissension, so I'll assume that's agreement. So we'll set that for end of next week. Thanks, Deb.
That's perfect. Thank you.
Okay, so with that, we can open the floor to public comment on item 8.
This is the moderator. I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click that Q&A icon located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, looks like we do have one request for public comment. Individual identified as Angela Perry. Angela, you'll be given 3 minutes to speak and a 30-second warning. I'm requesting to unmute your microphone now. All right, and you are unmuted.
Thank you so much, moderator. And thank you all members of the advisory committee and Bureau staff. This has been a long day and I know that this is the last thing, so I will be brief. I did just want to say that I really appreciate the thought that went into creating this plan and these goals. I agree that there is always room for improvement, and measurability is definitely important, especially as we are trying to make improvements and show evidence of those improvements. I definitely think that is valuable. I really do. One thing I wanted to emphasize, I agree that it would be valuable to incorporate language potentially about coordinating with other agencies. I hate to be a broken record on complaints, but I will mention that one of the things that our research really found was that there was at best informal coordination and often no coordination between various regulatory and law enforcement agencies nationwide, and that as a result students often get trapped in the gaps and either don't know where they can complain or don't really complain to the right place, and then things don't get connected, dots get left. And so anyway, just wanted to, at the end of the day, emphasize the importance always of coordinating with other agencies, but again, to emphasize the thoughtfulness that it is apparent that the Bureau took in crafting these goals and in thinking about the strategic plan. So just wanted to express appreciation for that careful work here and in all aspects of the Bureau's work. Really appreciate all of the time and energy that went into preparing the materials for today in general. So, okay, with that, I will end. Thank you all so much.
All right, this is the moderator. Appears that was our only request for public comment. Would you like me to close the Q&A feature?
Yeah, thank you.
All right, the Q&A feature is now closed.
And Angela, I want to say I appreciate how you ended your comments like Elvis leaving the stage. It was added a nice little flair to our last comment on the items on the agenda. So with that, we are down to our last item, which is future agenda items. So I'll open the floor to the committee to discuss if there's anything specifically that they would like to discuss at a future meeting for the Bureau's consideration.
I think that the question on 118 has been substantially narrowed, but I do think we need some follow-up on that in light of the comments from, I guess, Joseph and Kate and from me. And I realize it's a diminishing size of students we're talking about, so, you know, we've got lots of things on the agenda, so I realize you don't need to or can't really spend an inordinate amount of time on this, but it does seem to me like we still need to deal with that sort of narrowing field and both the absolutist area, which is very narrow, and the gray area as to how we might deal with that in the future, and whether we still need any sort of legislative amendment on that. I really appreciate what a substantive list of issues this was today, even though I know it's a long meeting and people are probably tired, but I really appreciate the work that has gone into this and pulling all of these issues together so that we could talk about them and try to be useful. And other than that, I think obviously, coming back with draft regulations as they're ready, and at that point, I guess we will either know whether there is or isn't something on SB 802. So I'm sure there's other issues which I can't think of right now, but I can send something if anything else comes up. But thank you very much for having such a substantive meeting.
Well, unless there are other ideas, I would just say thank you all for your engagement with and thank you to the entire Bureau of staff whose work has fed into all of the work that went into this. I know it was a lot of ground to cover. I know I, for one, am exhausted. I'm sure you all are too, but did want to make sure that no piece of this would have been possible without the whole Bureau staff here working on these pieces too. So thank you to all of them.
I have one suggestion for a future agenda item, which probably could be nested within the STRIF report in the next cycle. The outsized impact of the single closure of Silicon Valley College, which was a relatively small school. And I heard several references that we're not that familiar with the background. I myself am not that familiar with what that was, other than just doing some cursory research. There's a large number of international students, and that's we are all very familiar with the Corinthians closures and ITT and some other very large profile closures. None of them are even 20% of the financial liability STRIF resulted in from that Silicon Valley closure. So if we could maybe get a little bit more detail from the BPP perspective on what made that closure unique and why it was such a large impact to the STRIF.
Oh, and also, and I think you probably already had this on or will have this on the agenda, is the point that David raised, and that is obvious to us related to the Silicon University, whatever it is, that the impact on STRIF and where we are on STRIF at our next meeting.
Absolutely, for both of those.
Anyone else? All right. I'm not sure if we normally do public comment for this, but because normally under item 2, we take whatever was in the public comments for not on the agenda as future agenda items, but I will open it up to the floor for public comment anyway, just to be safe. If you already made a comment about something under number 2, that was a request for something to be added for a future agenda item, you don't need to tell us again. But if there's anything that we discussed that you think warrants another future agenda item that has not been suggested, we will open the floor to the public for comment at this time.
All right, this is the moderator. At the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on future agenda items, please click that Q&A icon located at the bottom right-hand corner of your WebEx screen. Go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, looks like I do have a request from Angela Perry. Angela, you'll be given 3 minutes to speak in a 30-second warning. I will request to unmute your microphone now. All right, and you are unmuted.
Hi, all. Can you hear me? I'm so sorry. I think my mic cut out at the end of my last comment.
Yes, we can hear you now.
Okay, perfect. Okay, I'm so sorry. Okay, so I had one thought. This is Angela Perry with TICAS. Appreciate this opportunity to comment. One thought that I had and that I've had several times today as we've been talking about Silicon Valley, and other colleges that may have suffered from the Dream Center. That was the one that we mentioned earlier, which was a conversion from a for-profit to nonprofit. It may be beneficial to incorporate, as we are thinking about that, a discussion of AB 70, which was passed in 2020, which created a safety guard against those kinds of conversions, those conversions in name only. And so that may be beneficial to think about that as we are also thinking about some of these other elements. So just wanted to put that out there as something that might be useful as we are thinking about some of these large scale closures or impacts on STRIF, how AB 70 fits into all of that might be something that's worthwhile to consider. And with that, thank you again so much for a wonderful day and for all of the hard work that I know went into preparing for it.
All right, this is the moderator. It appears that was our only request for public comment. Would you like me to close the Q&A panel?
Yes, thank you.
All right.
All right, everybody. We made it. I think this may be the longest meeting we've had in the past couple of years. So appreciate everyone's engagement and discourse and great suggestions and great conversation. I appreciate everyone's time. Is there anything else that anyone wants to add before we adjourn?
Thank you all.
All right then. So I think our next meeting will be November. And I know that there was some scheduling stuff going on with that, but I think we did confirm the date. I don't remember what it is, but I'm sure Richie will make sure that we remember before that date comes. So with that, I will adjourn the meeting and see you all. Oh, you know what? Before I do, Debbie, do you have any insight on, well, it sounds like maybe Carrie was saying at the beginning that there's a possibility that we could be in person in November, but it's still kind of up in the air. Is that your read on the November meeting as well?
That is my understanding as well. That we'll have to just wait and see what's coming. And just to confirm that the date we did originally have a different date, but it's been rescheduled to November 3rd.
November 3rd. Okay, great. Thank you for confirming that. And we'll find out more about in person or this again when we get closer to the date. So thanks everyone again for joining us. And with that, we can adjourn and go about the remainder of your day.
Thank you. Bye-bye.
Bye, everyone.
Bye.
Bye, all.